SCOTUS, Pontius Pilate, the man who could have saved Jesus but didn't. Wash my hands. Nothing I could do. SCOTUS, and I know Barnes is going to say it, has pulled another Pontius Pilate. Biden versus Missouri, the case which on a factual basis had government interference, government intimidation, government coercion of social media companies. It had it documented to such a thorough degree, they got an injunction enjoining the Biden administration from directly or indirectly pressuring social media companies to censor, et cetera, et cetera, et cetera. Went to the, I would say Fifth Circuit, but I'm not sure. And then it went to the Supreme Court, where 6-3, it was overturned on the basis that, let's see, is this it? Why was it overturned, everybody? Standing. The Supreme Court determined that the states did not have standing, nor did the individual plaintiffs, to sue the government because the damages that they alleged were prospective, future for potential censorship, such that they had no legal standing to bring the claim, or insufficient legal standing to bring the claim. Maybe there's someone else out there who has sufficient standing to bring the claim, but it wasn't the existing plaintiffs. Supreme Court Wednesday, and who was on it? There's a blistering dissent. I mean, we're all hearing the same talking points. There's a blistering dissent of Amy Coney Barrett, but it was 6-3. It wasn't even 5. I mean, whatever. We'll talk about it more on Sunday. Supreme Court on Wednesday rejected arguments by Missouri and Louisiana that the federal government violated First Amendment in its efforts to combat false, misleading, and dangerous information online. The irony is, in their attempt to combat misinformation and disinformation, they engaged in censorship of information which, over the long run, has proven to be more accurate than what they were claiming was disinformation at the time. 6-3, written by ABC or ACB. Excuse me. The court held that neither the states nor the 7 individuals who are called plaintiffs in this case were able to demonstrate any harm or substantial risk that will suffer any harm, injury in the future. Therefore, they do not have legal standing to bring the case. Plaintiffs failed to prove that social media platforms acted due to government coercion, Barrett wrote, rather than their own judgment and policies. In fact, she wrote, social media platforms began to suppress the plaintiff's COVID-19 before the defendant's challenge communication started. It's so amazing that they've greenlit how the government can go about censoring information under the pretext of dissent. They've greenlit it, and they've set out the blueprint to how to repeat it in the future. Plaintiffs cannot manufacture standing, Barrett wrote. Merely by inflicting harm on themselves based on their fears of hypothetical future harm is not certainly impending. The ruling overturns a lower court decision that concluded officials under President Joe Biden and Donald Trump unlawfully coerced social media companies to remove deceptive or inaccurate content. Out of fears it would fuel vaccine hesitancy or upend elections. Oh, in his dissent, Alito wrote that the government's actions in this case were not, quote, ham-handed. In his dissent, Justice Alito wrote that the government's actions in this case were not, quote, ham-handed censorship, end quote, that the court had routinely rejected, but were coercive and illegal all the same. It was blatantly unconstitutional, he wrote, and the country may come to regret the court's failure to say so. If a coercive campaign is carried out with enough sophistication, it may get by. That is not a message this court should send. It is exactly that message that the court has sent. You remember, it's such an amazing thing. It came out during the Taibbi Twittergate. Ooh, excuse me. It came out during the Taibbi Mehdi Hassan public debate. How did that turn out for you, Mehdi Hassan? Didn't turn out well for you, pathological liar. Where Mehdi Hassan called Matt Taibbi a liar, saying that he was lying about the influence or the interference with the Twitter files. And my nose is itchy. Hold on. Let me see. I think I brought it up. I think I had the video here. Other than trying to, yeah, this is it right here. Bada bing, bada boom. Check this out. Here, let me play this video.
There was a lack of capability around election disinformation. This is not because CISA didn't care about disinformation, but at the time they lacked both kind of the funding and the legal authorizations to go do the kinds of work that would be necessary to truly understand how election disinformation was operating. So because of the feedback and the ideas from this group, we were able to pull together pretty quickly a project between these 4 different institutions to try to fill the gap of the things that the government could not do themselves. there was
like, this is the Election Integrity Project back in the day. What was my tweet with this here? Because I know that I was laying it on thick to Mehdi the liar. Wait, donc, qu'est-ce qui se passe ici? Other than trying to discredit Matt Taibbi on an error that seems to be immaterial to the underlying point, I don't understand what else Mehdi Hassan is trying to prove here. One, CISA was a partner of the EIP, Election Integrity Project Partnership, by their own admission. Election Integrity Partnership prepared reports of what it believed were falsehoods and submitted those reports to social media platforms. EIP was, by its own admissions, filling the gap, that's a quote, and doing what government could not do despite partnering with government agencies. 4, intelligence was meeting regularly with social media platforms, planting disinformation as relates to the election, Hunter Biden. What do you disagree with, damn it, on these points? And if you don't disagree with these points, Mehdi, do you not understand what an outrage it is? And I have the link to the thing here. What we have that the Supreme Court in the 60s, I mean, they didn't ratify it really. They're saying, oh, well, you guys didn't suffer injury. You guys lack the standing, so we don't have to adjudicate on this issue for now. And, Amy Coney Barrett basically saying, look, your damages are hypothetical, self-inflicted. Oh, you self-censored, so we don't have to address this issue anymore. I know that there has been disagreement among lawyers. Barnes often says standing is a made-up Pontius Pilate judicial precedent. It does not exist in the Constitution. It's the court's cowardly way of getting out of adjudicating on issues when they don't want to. Simply say no standing. So you don't get to make this claim. Someone else might down the line. Maybe then we'll have to deal with it. We'll let it go up the hierarchy. But for now, no. And by the way, just in time, what month are we in now? What month are we in now? June? We're getting close to July. July, August, September, October, November. 5 months to election day, people. Now the government can go ahead and go back to its surreptitious and I would dare say improper. That's not the right word. Surreptitious, insidious, and deceptive interference with social media companies. The only massive difference now than when this lawsuit was initiated, Elon Musk owns Twitter, and Chris Pavlovsky has been changing the world with Rumble. So good luck trying to do what they were doing with Twitter back in the day, censoring the Hunter Biden laptop story, having third-party NGOs do what the government can't do directly. The Supreme Court has all but ratified it, or at least facilitated it. And that's the Pontius Pilate decision of the day. Washing their hands of doing what they have to do here. Murdy, here we go. Let's go here. So I mean, we're not going to read the whole thing because they go through it's verbal diarrhea. This is to ensure that nobody reads this 68-page decision. The dissent is great, but they go through all of the legalities. Is just fill up the pages so that nobody reads it. This is in the summary. The plaintiffs fail by and large to link their past social media restrictions and the defendants' communications with the platforms. Yeah, because it was done so insidiously. It wasn't overt coercion. It wasn't overt bribery. It's just a wink, wink, nudge, nudge. Let's send the FBI to meet with Zuckerberg. The state plaintiffs, Louisiana and Missouri, refer only to action taken by Facebook against Louisiana state representatives' posts about children and the COVID-19 vaccine. But they never say when Facebook took action against the official's post, a critical fact in establishing a causal link. How about the fact that the government did it? They pressured Facebook. They pressured Zuckerberg is on freaking Joe Rogan talking about it. Oh yeah, we don't have the proverbial gun to the head, so no standing. Nor have the 3 plaintiff doctors established a likelihood that their past restrictions are traceable to either the White House officials or the CDC. They highlight restrictions imposed by Twitter and LinkedIn, but point only to Facebook's communications with White House officials. Why would they be having communications with White House officials? Plaintiff Jim Hoft, who runs a news website, experienced election-related restrictions on various platforms. He points to the FBI's role in the platform's adoption of hacked material policies and claims that Twitter restricted his content pursuant to these policies. Yet Hoft's declaration reveals that Twitter took action according to its own rule. Oh my, can they be freaking dense when they want to be dense? According to its own rules against posting private, intimate media without consent. Hoft does not provide evidence that his past injuries are likely traceable to the FBI or CISA. Plaintiff Jill Hines, a healthcare activist faced with COVID-19 related restrictions on Facebook. Though she makes the best showing of all the plaintiffs, most of the lines she draws are tenuous. Yeah, because we don't have the email that says, take it down or we will sick the IRS on you. Take it down or we will investigate you for whatever the heck threats they've made against Elon Musk. Plus, Facebook started targeting her content before almost all of its communications with the White House and the CDC. Wow, it's amazing how this corruption works, thus weakening the inference that her subsequent restrictions are likely traceable to government coerced enforcement of Facebook policies. Even assuming Hines can eke out a showing of traceability, the past is relevant only insofar as it predicts the future. Oh, let's see here. To obtain forward-looking relief, the plaintiff must establish a substantial risk of future injury that is traceable to the government defendants and likely to be redressed by an injunction against them. The plaintiffs who have not pointed to any past restrictions likely traceable to the government defendants are ill-suited to the task of establishing their standing to seek forward-looking relief. Can you imagine that they're going to say, we have all the facts, we have all of the reality of what government interference does in the past, present, and what it will do in the future. You guys aren't the best. You know, someone else. When you get someone better, maybe then we'll figure out another way. Oh, they're latches. They didn't act in time. But even Hines, with her superior showing on past harm, has not shown enough to demonstrate likely future harm at the hands of those defendants. On this record, it appears that the frequent, intense communications that took place in 2021 between the government defendants and the platforms had considerably subsided by 2022. Listen to the way the frequent, intense communications between government and social media. It had plateaued. It subsided by 2022 when Hines filed suit. Thus, it is, quote, no more than conjecture, end quote, to assume that Hines will be subject to government-induced content moderation. Well, it's a good thing they stopped beating you, because now you can't complain about the abuse. Pontius Pilate, cowards.